I am Tamara Arsalan, Associate Director of the Bridge Initiative. The Bridge Initiative is a multi-year research project housed within the Al-Walid Center for Muslim Christian Understanding here at Georgetown. The research project focuses on the nature and impacts of Islamophobia in the U.S. and abroad. Through our website, bridge.georgetown.edu. The Bridge Initiative disseminates original and accessible research, offers explanatory commentary on contemporary news, and hosts a repository of studies, polls, articles, and other research. Before I go any further and introduce our honored guests, I would like to thank the Center for Contemporary Arab Studies, our co-sponsors this evening. It is now my extreme honor to introduce our featured speakers tonight. Professor Shoba Wadhia of Penn State Law School and an alumna of Georgetown Law. Professor Wadhia is an expert on immigration law. Her research focuses on the intersections of race, national security, and immigration. Her work has been published in Emory Law Journal, Texas Law Review, Columbia Journal of Race and Law, Yale Journal on Regulation, Harvard Latino Law Review, and many others. Her work has been cited by federal court judges. She's also founder and director of the Center for Immigrants' Rights Clinic, which provides legal support for applicants for an immigration benefit or those challenging deportation proceedings in federal courts. She's a frequent guest on MSNBC and other outlets and is published in the New York Times Magazine, The Hill, National Law Journal, Washington Post, Wall Street Journal, The Atlantic, Associated Press, and others. Professor Wadhia's comments on the Muslim bans will start our program. She'll speak for about 20 minutes and will be followed by a conversation with the Bridge's own Professor Arsalan Iftikhar, who the conversation will contextualize the Muslim bans in the context of Islamophobia discourse more broadly. Arsalan is a senior research fellow at the Bridge Initiative, but he's also a human rights lawyer, a global media commentator, and author of the book Scapegoats: How Islamophobia Helps Our Enemies and Threatens Our Freedoms, which President Jimmy Carter cited as an important book that shows Islamophobia must be addressed urgently. Arsalan is also a regular on-air commentator for NPR, CNN, Al Jazeera, BBC World News, The Economist, New York Times, Rolling Stone, NBC, Meet the Press, and on and on. Arsalan will then moderate questions from the audience. So first our address with Professor Wadhia, conversation with Arsalan, and then Q&A. We're on a rather tight schedule because Professor Wadhia has to fly out at 8:30 tonight, so I'll be a timekeeper. But be sure to follow us on Twitter at BridgeInit, that's Bridge, I-N-I-T, BridgeInit. And for tonight's event, use the hashtag #NoMuslimBanEver to follow.
It's actually going to be Wadhia, G-U.
Oh, it changed. Good. New hashtag to follow tonight's event. And a discussion we'll be having online, right? We're still doing that? Good. So with that, please help me welcome Professor Shoba Wadhia.
Thank you for that very generous introduction and for the very warm welcome from the Bridge Initiative, and good evening.
Good evening.
It's great to be here. As mentioned, I'm an alumna of Georgetown Law, 1999, And so when I started immigration practice, I practiced before the old immigration agency known as the Immigration and Naturalization Service. So things have changed since then. So how did I get here? This just gives you a sense of my main loves outside of my family, beginning with the Immigration and Nationality Act, which has been compared second in complication to the US tax code. It was introduced by Congress in 1952, has been amended many times since. And so I spent my first several years after law school practicing right here in DC, largely deportation defense, family, employment, asylum, protection against the Convention Against Torture cases, and so on. After 9/11, I moved on into the policy space and worked as a lobbyist on a range of issues, beginning with the controversial debate to create a mammoth agency known as the Department of Homeland Security. 10 years ago, I moved with no connections to the state of Pennsylvania to start the Center for Immigrants' Rights Clinic at Penn State Law in University Park. And we'll have our 10-year anniversary in July. And law students work on a range of cases, including the support that was mentioned in the introductory remarks, community outreach and education, as well as policy work on behalf of organizational clients. I also teach immigration law and asylum and refugee law, and the issues that we'll talk about today are near my heart personally as well. So we are all starting with the same vocabulary. Let's talk about sources and terminology. Immigration 101. Let me highlight a few sources. We've all heard of the US Constitution. The Constitution applies when we talk about immigration. We've talked too about the Immigration and Nationality Act. These two sources, the US Constitution and the INA, have been the main legal sources that are subject in the ban litigation. Executive orders and proclamations. These are documents that come out of the executive branch. They are signed by the president. They are legally binding. I sometimes get asked, what's the difference between an executive order and a proclamation? Why the change from 1 and 2 to 3? They're not really different. As a matter of law, they have a similar effect. They are close cousins, let's say. But in neither case can an executive order or proclamation conflict with the Immigration and Nationality Act or violate the US Constitution. So who are the main players in immigration and the debate around the bans? This clicker has a mind of its own. So the Department of Justice is an agency perhaps we've all heard of. It's a federal agency. It houses the immigration court system. It's also the agency defending the federal government on these bans. The Department of Homeland Security, that's the new mammoth agency I mentioned, houses 3 sub-agencies: USCIS, CBP, and ICE. There's a lot of acronyms in immigration law, as in many other types of administrative law. They become important because USCIS is responsible for processing immigrant visa petitions, for example. And CBP is responsible for inspecting people at the border and making a decision whether or not someone should be admitted into the United States. And the Department of State, an important agency as we think about the role and the practical impact of these bans. They play a role in actually issuing visas to individuals. So once a petition has been approved by the Department of Homeland Security and a visa becomes available, given the long queues under our statutory framework, then only will the individual attend a visa interview at a consulate that is housed by the Department of State. More terminology, and this is my last terminology slide. Immigrant and non-immigrant. These are important terms as well. Immigrant refers to somebody seeking admission into the United States on a permanent basis. So based on sponsorship from Microsoft or another US employer, an individual may qualify for a permanent visa and later a green card. Or based on a family relationship. So a foreign national falls in love with a US citizen. That is a qualifying relationship under US immigration law, and that is a person who is seeking admission as an immigrant. Contrast that to non-immigrant. It doesn't mean they're invisible, right? Instead, it refers to those who are seeking admission on a temporary basis. So that might include a student, a Fulbright, an individual who is coming as a tourist or for business purposes, and non-immigrant plays a specific role around these bans. Lawful permanent resident. Sometimes newspapers and lawyers call it legal permanent resident, but actually it's formally called lawful permanent resident. It is the fancy or formal way of calling a green card holder. So once you have acquired lawful permanent residence, you hold in your hand a green card, although the cards are not always green. So federal courts, what can I tell you about them and the ever-shifting slides? Well, we have been ever-shifting in these courts. I would like to tell you that the trajectory of this litigation has been as linear as the slide. The federal courts work in a way where the lowest court, or the first court you go to, is a federal district court. And there are district courts all over the country. If you are unhappy with that decision, a losing party might then appeal that case to a federal court of appeals. And there are federal courts of appeals all over the country. And then eventually, or perhaps quickly, as this administration has shown, you might then request or ask the US Supreme Court to do something. The litigation in the bans have been nothing but linear. There's been a lot of ping pong. There's been district court to Supreme Court. There's been district to appellate and Supreme Court at the same time. And we'll talk a little bit about what the litigation has looked like during the course of tonight's discussion. So here is our president, Donald J. Trump. And he issued his first set of executive orders on immigration, not 3, not 4, but 5 days after inauguration, on January 25th, 2017. He issued twin orders on immigration enforcement. And I want to at least mention them because we can't look at all of the changes to immigration policy in silos. They are connected in one way or another. And the immigration enforcement orders apply to people who might be arriving at the border or who are already inside the United States. And they impact the Muslim, Arab, and South Asian community in meaningful ways as the bans do. 2 days after that, a Friday for students in the room, we're looking at a week or two after the winter semester started. So it's Friday, 4:30 p.m. How many are in class, right? This is when the first executive order was signed. And it was signed and became effective immediately. And that's what led to some of the chaos that we saw at the airports on that weekend. So what does version 1, and I'm sorry to keep looking up at the slide. I don't normally do that, but this clicker has a mind of its own. So the terms of version 1 of the ban are that individuals who come from 7 designated countries are blocked from entry into the United States. All 7 of these countries have Muslim populations of 90% or more. The refugee admissions program was suspended for 120 days. The Syrian admissions were indefinitely suspended. So these were some of the features of version 1 of the ban. And as I mentioned, the effective date was immediate. Of note, there was no consultation made with the administration's own lawyers before this ban was made into effect. So this next shot is one of 2 overflow classrooms at Penn State Law. We've held a number of community forums on the ban. Penn State University is the 4th most affected university in the country by the ban. So the chaos that it caused to a university and the connection I have to some of the arguments about the injury that these bans have on actual universities, the ability for faculty and students to travel, to do research, to come back into the United States, these became very tangible and real within 24 hours of the first ban. In addition to doing oral community forums, like with many organizations in Washington, D.C., we put out a number of fact sheets that we tried to put out in plain English. 2 partner organizations in D.C. Are ADC, the American Arab Anti-Discrimination Committee, and Muslim Advocates. So this just gives you an example of one of our fact sheets. And like the Bridges Initiative, one of our mission and goals in the clinic is to take very complicated information and boil it down into 2 pages, or plain English, in an accurate way. Almost immediately, we saw lawsuits around the first version of the ban. Kristen, oh, here we go. We might have a low battery, so I may switch over to the arrow if that's okay, thank you. So there were multiple lawsuits filed in connection with the first version of the ban, but the one that received the most airtime, if you will, was a district court decision in Seattle, Washington, that was later appealed to the Ninth Circuit Court of Appeals, and the courts held that version 1 of the ban was likely unconstitutional. And in violation of the statute. And so when you hear the word "is likely" unconstitutional or in violation of another law, what that means is a decision is being made about is there an injury, is the party likely to succeed on the merits of the case, is it in the public interest? These are some of the questions that are asked before judges make a decision about whether a preliminary injunction is necessary. So this was a nationwide injunction, so it applied to the entire United States. And for those who stay up at night thinking about nationwide injunctions, it's been a hot debate in the last 6 months or so, because we're seeing more and more courts using nationwide injunctions. Is that good as a normative matter, as a practical matter? Ironically or coincidentally, many of these courts have been citing to a case that was handed down under the Obama administration called Texas versus United States to justify the nationwide nature or need for these injunctions. And if you want to talk about Texas v. US, I'm happy to do so in the Q&A. So version 2, oh, thank you. All right, I'm going to stop this clicker now. Version 2 of the ban, and for students in the room, day 1 of spring break, was handed down on March 6, 2017. And by issuing version 2, the administration extinguished version 1, dropped Iraq from the list of countries, dropped the indefinite nature of Syrian refugee admissions, and put a 15-day delay period between the date on which the executive order was issued and the date on which it would be implemented. And the idea behind it, presumably, was to avoid those bad scenes at the airports, right? So that there was some time before the ban, in fact, went into effect. Next slide. So the litigation for version 2 of the ban, and I'm going to break my rule twice in this presentation by giving you slides that have too much text. There's just no other way, and it's still boiled down as much as I can. The litigation was really complicated with 2.0. There were lawsuits filed in district courts, the most prominent of which were a federal district court in Hawaii and a federal district court in the state of Maryland. Those decisions were appealed by the administration to the 4th Circuit Court of Appeals and the 9th Circuit Court of Appeals. And then the administration asked the U.S. Supreme Court to let the orders go into effect anyway, and to hear the case. And so we got this really strange per curiam opinion in late June of 2017 by the US Supreme Court that did this. It partially reinstated the ban for anybody who lacked a credible bona fide relationship to a person or an entity. What does that mean? There is no such thing as a bona fide relationship in the immigration statute. So if you go through that complex code, we do not have a definition certain for what a bona fide relationship means. Now, the court did offer a couple of examples, such as a university student who applies to school and is accepted, so maybe that acceptance letter, or a close family relationship. But the examples were by no means exhaustive, nor were they clear enough for the standard itself to be implemented on the ground in a practical way. On that same day, the US Supreme Court also granted cert, which is a formal way of saying, yes, we will hear this case. Immediately, lack of clarity ensued on what is a bona fide relationship. And the Department of State and Department of Homeland Security issued guidance in a very narrow way. So the first renderance of the guidance on bona fide relationship excluded grandmas, grandpas, fiancés, aunts, uncles, cousins, right? I think I saw almost every one of those family members during that month, that these very family members were excluded from the agency's formulation. Eventually, fiancés were added. Eventually, so too were grandparents. In fact, the judge in Hawaii said, grandparents are the epitome of family. But nevertheless, there was still a lack of clarity and confusion over what someone might need to show to document a bona fide relationship, and so on. Next slide. And so this is just an idea to tell you that this bona fide relationship standard, which was really a invented standard by the US Supreme Court, you might ask whether it was necessary at all. Could the court have issued or granted cert without partially reinstating the ban, and did they have to do it in this manner that caused a lot of confusion? So time only deepened the wounds, and if we get to the next slide, we get to version 3 of the ban, which this time was issued not as an executive order, but as a presidential proclamation. And in the same breath that this proclamation was issued, oral arguments in the US Supreme Court case hearing version 2 of the ban were canceled. And what you see in the green are the countries that were added to this proclamation. Sudan was dropped. And the theory of the administration was to show that this wasn't really a policy that was targeting Muslims. I mean, come on, Venezuela is on there. But the reality is, we don't have a large number of North Koreans coming into the United States. And if someone wants to talk about why, and is a diplomacy expert, I'd love to hear it. And also the exclusion on Venezuelans was so narrow. It was limited to very limited government officials who were coming in on B1 and B2s and their family members. And Chad, it is a Muslim majority country, right? And so perhaps the administration here felt like it had solved its problems in the courts by issuing a ban that perhaps looked a little bit more neutral. Next slide. A few more notes, because there's a lot to share, both on content and on process and journey. There were exemptions listed. The court got smart and said, we need to be a little clear about who is exempt from these bans. And so versions 2 and 3 have these exemptions. You may recall that the first weekend of ban number 1, it was unclear whether green card holders were allowed in. So now lawful permanent residents are specifically exempt. So too are people who had a valid visa on the day of the effective date. Next slide. Another interesting add-on to versions 2 and 3 of the ban was a waiver scheme. So these are people who don't qualify as an exemption, don't have a bona fide relationship, so essentially are covered by the ban. They may qualify for a waiver on a case-by-case basis by the consulate if they show three things. Undue hardship if they are denied entry, that their entry is in the national interest, and that they do not pose a national security threat. Undue hardship is another term that is nowhere in the Immigration and Nationality Act. Waivers are exhausting and take up a lot of resources by the Department of State. There wasn't really a lot of guidance on how these waivers would work. There were 10 examples provided, but to this day, we don't have real guidance from the Department of State or the Department of Homeland Security on these waivers. Next slide. And so a natural next question for me is, are these waivers a sham, right? Is this a waiver process that the president put in place for some type of legal protection, but on the ground, is it a type of system where waivers aren't even being considered? And so one thing that I've done along with some other organizations is to document cases where people were denied visas under the proclamation and never considered for a waiver, or were denied a visa and brought paperwork in support of their waivers, and the consulate ignored it. And we've seen more than a handful of cases where this has occurred. Next slide. So this is my second slide that has too much text. And this is the litigation around the presidential proclamation. Same main courts in play, and same trajectory at the appellate courts. A longer delay, however. For example, we did not get our appellate decision by the Fourth Circuit until last week, and that decision was 285 pages. Before then, on January 19th, the US Supreme Court granted cert. And before that, on December 4th, the US Supreme Court issued these twin orders that were a little strange, that said something like this. We are going to reinstate the entirety of Ban 3.0 pending decisions at the appellate court and pending any decision at the Supreme Court if the losing party chooses to apply for cert. Wow. Okay, so you've made no decision on the merits of whether this presidential proclamation is consistent with the statute or the Constitution, but you are going to fully reinstate the ban until you make a decision. And so the human impact on the ground is profound, because it means that between now and at least June, families are separated, right? Iranians who are studying at Penn State cannot have their parents visit. Syrians who've been courted by departments for their postdocs can't get in. And so there are practical impacts, including family reunification, that are front and center with the full force of the ban in effect. Next slide. So one thing interesting, because I don't have time to go through all the passages of every court decision, but I'll take out one from the Fourth Circuit Court of Appeals from last week. Because this is a court that really found likelihood of success on constitutional grounds. And it was very compelling, and there was more than one statement where the court said, we don't even need to rely on the statements that the president made before the election, right? His inauguration did not herald a new day, quote unquote, by the Fourth Circuit. And so they found under a test called Mandel that the order was not bona fide, and also found that it was not made for a secular purpose, and did so by identifying the harms that are related to animus and the feelings of marginalization by the plaintiffs who brought their lawsuit. Next slide. So what can we expect at the US Supreme Court? I have no idea. But these are two major legal buckets. One is the INA bucket, and it's my love, as you know, after my children. So I'm happy to talk to you about the sections of the INA that are in play. I will also say that one other statutory argument is that the proclamation itself disturbs the entire statutory framework of the INA, because the president is essentially rewriting the immigration statute that Congress put into place. And so one amicus brief that I'll be involved in before the US Supreme Court is to talk about the legislative history of the Immigration and Nationality Act and how this presidential proclamation almost brings us back to a pre-1965 era when we had national origin quotas and the like. There will also very likely be briefing on the constitutional grounds, and with the Fourth Circuit decision, it's really unknown where the court might go, whoever wins or loses. What we do know is that the ban today is impacting people and families in profound ways. Next slide. However the court rules, we know that there's been some type of victory and success in the resistance, right? There's been great resistance outside the courts against these bans, and a powerful message that these bans are really inconsistent with American identity and who we are. And so there's been an incredible surge of resistance and mobilization that cannot be forgotten, regardless of what plays out in the courts. So let me end there. I have a few resources on the side. Of course, Bridge Initiative, first resource, but there are a few others here. Penn State Law's Center for Immigrants' Rights maintains a clearinghouse of all things immigration post-election. And so there we have a lot on the bans, as well as DACA, TPS, and so on. And I'm really looking forward to the discussion and questions. Thank you.
So, Professor Wadhia, you mentioned, it was an illuminating talk, especially for a lawyer like me. Even I'm confused by a lot of this stuff. And so, I have a lot of questions that I think might help unpack some of the context around what you talked about. And so I was wondering if you could first just give a little bit of context in terms of NSEERS and special registration, what happened back then during the Bush administration, and how you think that might tie into some of the deliberations that might have been undertaken by the Trump administration.
Sure, and there are certainly some parallels that we could make between immigration policy making in the wake of 9/11 and immigration policy today. I do think there's a difference, so I might start with what that difference is. President Bush did not come out on Twitter, did we even have Twitter, and national television disparaging Muslims openly. So I think that level of explicit animus against the Muslim community is a little bit more unprecedented under this administration as compared to the Bush administration. Having said that, there were a number of executive branch policies that were issued as a national security policy, but that on the ground targeted Arab, Muslim, and South Asian communities. And the NSEERS program was created by the former Attorney General, John Ashcroft, and implemented first by INS and later by the Department of Homeland Security. And as you mentioned, one component of the program drew in men from 25 countries, all but North Korea, were Muslim-majority countries. And it was pretty stunning because they voluntarily came forward to comply with the program that was dubbed as national security. They were questioned, they were interrogated, they had photographs taken of them. But if they had a visa violation or another reason for being in violation of the immigration law, they were given a charging document known as a notice to appear. So it really begs the question, first, what is the national security value? And how are you finding terrorists by asking them to voluntarily come into the office to register with the government? Most terrorists are not going to self-identify themselves. Second, the lack of notice. My My favorite but accurate talking point at the time was how many 16-year-olds read the Federal Register over breakfast, right? That was really the notice for the registration program. And then finally, what became of the program was that it was a law enforcement tool to deport people from certain nationalities and certain countries. Eventually, the MCERS program ended by the rescission of the rule right before inauguration. But that was a long journey. The MCERS program stayed on the books for well over a decade, and continued to impact families long after the Bush administration, especially those who, for example, may have never registered in the past, and today were at a green card interview with a wife, US citizen, and has now at this point laid down roots. So there are certainly parallels between 9/11 and now, but this is more like MCERS on steroids, right?
Yeah, absolutely. And I think it's important to keep in mind also for our audience members that the animus that we talk about when it comes to Donald Trump and Islam and Muslims began well before he ever became president. The very famous soundbite of him saying that, I, Donald J. Trump, call for the complete shutdown of Muslims from entering the United States until we can figure out what the hell is going on, was actually made shortly after the San Bernardino shooting in December 2015. In subsequent interviews on the campaign trail, Donald Trump once famously told CNN's Anderson Cooper that, quote, "I think Islam hates us," as though Islam's like some 6'2" bully, punching him in the cafeteria. Just looking around the Trump White House in terms of the people who began his administration to advise him, from Steve Bannon to Sebastian Gorka to Steve Miller to outside advisors like Frank Gaffney. They have. I mean, if you go to our website for Bridge Initiative, we have fact sheets on all of these White House advisors and their long history of Islamophobia. So again, it wasn't just that Trump woke up one day and said, I'm deciding today not to like Muslims. Islamophobia has become a central component of the Trump administration, and I think that's something important to keep in mind. My next question to Professor Wadhia is another a talking point, more of a buzz phrase that a lot of Trump supporters use, and that is the phrase of quote-unquote extreme vetting. We hear that, we've heard that routinely for the last several years. And that leads me to my question on the refugee process here in the United States. First of all, many people use the terms refugee and asylee interchangeably. So I was wondering first if you could explain the distinction between the two, and then also, more importantly, if you could sort of outline the refugee resettlement process, and the extreme vetting that already goes on. You mentioned the 2-year process, the nearly 2-year process that many refugees undertake. But if you could sort of just outline that a little more, just so we're aware that any refugee who comes to this country has already been extremely vetted. But I think just making that distinction and running through that process would be helpful for myself and for many people here.
Sure. So if somebody is admitted into the U.S. as a refugee, they are processed through our overseas refugee program. And so they are treated as a refugee in the formal sense. For somebody who's already in the United States, so I'm a student at Georgetown University, I'm from Syria, I fear a return, then I still have to meet that definition of refugee, but I apply for something called asylum. And so asylum, by its terms, is only applied to people who are physically present in the United States, and then who meet the definition as a refugee. There are other limitations on the asylum process, like you have to apply within a year of your last arrival. In terms of how the refugee screening or resettlement process works, typically, at least for U.S. refugees, UNHCR will refer individuals. They will have an interview by USCIS, so one of those hubs in the Department of Homeland Security, to see if they satisfy the refugee definition. And then they will undergo a number of background and security checks. The Department of State, the Department of Homeland Security, intelligence, FBI, and so there are lots of checks along the way before someone is actually admitted as a refugee.
Great. My next question is, you outlined the timelines of 1.0, 2.0, 3.0 in terms of the District Court, Court of Appeals, Supreme Court.
I tried, yeah.
Yeah, no, even for lawyers, it's hard to keep track of. You talked a lot about the bona fide relationship aspect, and you said that when were the fiancés or grandparents and cousins removed from that?
Pretty quickly. I mean, all of this happened in a very short period of time. So at the end of June, the court creates this new bona fide standard, and then immediately the agencies interpret that in a way that keeps out fiancés and grandparents. And any person who ordinarily thinks of a bona fide relationship goes wild, right? And then the courts go wild and say, what are you doing? And so the agency at that point then adopted the court's somewhat broader bona fide relationship standard so that it includes, for example, grandparents. That bona fide standard, though, has continued to stay in the litigation in some way or another. So even the decisions by the 4th and 9th Circuit Courts of Appeals around the proclamation. So that's version 3 of the ban. So even though this concept was introduced with version 2, the courts are continuing to adopt it with version 3. So I personally find that somewhat interesting. Now what the appellate courts do as a practical matter don't really matter at all because they stayed their own decisions pending a decision by the Supreme Court.
Interesting. And, a lot of analysts and commentators have said that and I'd love your opinion on this, that one of the ways that the Trump administration is trying to sort of run an end around on the Supreme Court ruling against them is by making these temporary 90-day, 120-day bans. That's what we have version 1.0, 2.0, 3.0, so that by the time it ultimately does get up to the Supreme Court, it's become moot because that 120, 90, whatever day calendar period has passed. Do you think that was deliberately done by the administration, or is that just something that happens to be coincidental?
Well, it's hard to know what was deliberate, right? And what was known to the administration when it issued its bans and unknown to the administration. I do think the initial thought might have been, oh, there's an end point. But we see with the 3rd version of the ban that there is no end point. I mean, there's this reporting requirement, but at the end of the day, the ban is indefinite. It doesn't have the 90-day period that we saw with versions 1 and 2. And
you mentioned the case of Texas v. U.S. And national injunctions, and I'm just a little, I don't know, maybe it was just the way that you presented it. Do you think national injunctions are a good idea or not?
So first, I'm not an expert on national injunctions, so I should full disclosure. I understand the sense for why national injunctions are being issued by federal courts on immigration matters, because immigration is a federal matter, and so the idea of having such a consequential decision apply to one part of the United States and not the other, to me seems like a bureaucratic nightmare, right? For the agency to partially implement a policy or a program.
I guess my final question before I wanted to open up to the audience is that when the Supreme Court decided to let the ban continue, if I'm not mistaken, it was an 8-1 vote, correct?
So the choice would, I think there were 2 dissenting.
Okay.
It's hard to know where they were on the twin orders because the way I understand decisions to reinstate or to stay an injunction, you don't necessarily have to make your vote known So we don't know exactly where each of the justices fell. We just know that a majority would have allowed for the injunctions to be stayed.
I see. And so what do you anticipate as the next steps? I mean, do you anticipate anything further in the near future? What do you think?
You know, this has been nothing but normal, but under normal circumstances, now that cert has been granted, oral arguments would be scheduled for March, April, and then a decision would be issued by the Supreme Court in June. So what I'm suggesting is that we can expect the full ban in effect until at least June.
Great. So having said that, I think we will open it up to questions both here live and via Hannah online. Again, if you don't mind, we'll call you. Please stand up, identify yourself, and then Professor Wadhia would be happy to answer your question. Yes, sir.
Jack Crescento, the George Washington Institute. Two questions. The non-immigrant visas. What's the longest non-immigrant visa that we give? So can you come as a 2-year, 3-year? I don't know if there's a time frame on that. When do they consider that you're an immigrant?
So some are as good as one's course of study. So it might be possible for a student to come in as an F1 non-immigrant and to be in the United States through their course of study. They might have to do paperwork in between. For certain temporary workers, an initial period might be 3 years, and sometimes the law allows you to extend your non-immigrant status. You know, the H-1B scenario is quite interesting because there is a 6-year cap in most cases for H-1Bs, but there are special rules that Congress has made to allow for certain extensions, especially for H-1Bs who are ultimately sponsored for green cards by their employers. And if you're in certain categories and you come from certain countries, the wait time is a really long time. So if you're an Indian national with an advanced degree pending a green card, you might be waiting for at least 10 years before you can apply for a green card because of the statutory ceilings and quotas that are in our immigration law.
Am I right just to understand what happened with the version 3? Did the lower court, it seemed like you presented that somehow they reversed the Supreme Court. Did I understand that wrong? The Supreme Court made a decision in December, and then you said after that, what did the lower court do after the Supreme Court?
Okay, so the presidential proclamation was announced in September of 2017, and in October, 2 district courts issued injunctions stopping the most controversial portions of the proclamation. And then an appeal was made to the 9th Circuit and the 4th Circuit. Meanwhile, the administration also asked the Supreme Court to do something. So in December, before the appellate courts had even made a decision, the Supreme Court said, we're going to reinstate the entirety of Ban 3.0, pending a decision by the appellate courts and/or our court. So that choice made in December by the U.S. Supreme Court was the trigger for the version 3 to go into full effect. And during that time, the appellate courts made decisions, but the ban was still in effect. And then last month, the Supreme Court granted cert. The ban is still in effect. And so we're still waiting because under those orders, we have to wait for an ultimate decision by the Supreme Court before we know whether and how these bans are in effect.
Yes.
Thank you. Michael Kutzik, graduate for many decades from Georgetown. In a somewhat different context, there are 65 million refugees around the world now. Can you give us an idea of what the impact of what's going on here has on other countries, on their legal system? In Europe, for example, where there are so many refugees seeking asylum. Other countries. Has there been such an impact?
So I'm not an expert on comparative refugee policies, but I would say that we're clearly not sending the right message around the world. But the countries that are neighboring to those who are fleeing civil war, for example, the impact they're facing and seeing is just so dramatically different for even how the U.S. absorbs refugees, right? We have a huge body of water, for example, between most of the countries and the United States. We also have a president that has set the refugee ceiling for the next fiscal year at 45,000, the lowest number of refugees since the Refugee Act was passed by Congress in 1980. I would hope that our refugee policy is not influential to how countries around the world absorb them. The screening processes are quite different. So sometimes when we hear, oh, well, Europe has a different policy in how they screen and admit refugees, that's likely true because most nation states set their own policies on how refugees will be screened and when they will be admitted.
When the Supreme Court does ultimately hear the case, in terms of standing, I mean, who is there the named plaintiff in that case? Would it have to be somebody who is not allowed to travel to the United States, just has relatives that are not allowed to travel to the U.S. under the 3.0 ban? How would that work?
It could be a mix, right? So in terms of the standing conclusions that have been made by the court so far, standing has been found for individuals, like the examples you mentioned, and also for states. So in the case of the Supreme Court, it's the state of Hawaii who is one of the plaintiffs. And so the state is claiming an injury. And some of that is tied to the university, right? And the loss to an entity or a university. So both entities and individuals have been shown to have standing in this case so far.
And when it comes to proving an animus towards Islam, or at least that the ban was meant to disparately impact Muslims in a negative way, aside from the Islamophobic rhetoric that Trump has said in the past, how high of a threshold is that at the level of the Supreme Court?
So the primary constitutional argument has been that the proclamation violates the Establishment Clause of the First Amendment. And the Establishment Clause of the First Amendment states that a government cannot favor one religion over another. And then we have a bunch of court decisions that try to interpret exactly what that means. And so one case that has been applied, which is not an Establishment Clause case, but has been a constitutional case applied, is called Mandel. And that case stands for this idea that first, a policy must be facially legitimate and bona fide. And if it is facially legitimate and bona fide, the court should not look behind that policy. And so that's the main argument that the government is trying to make. Now, if you look at the Fourth Circuit last week, they said, this is not bona fide, right? So if you don't pass that test, then the jurisprudence says you can look behind that policy. And then you need to decide, whether there was a purpose. Was the purpose secular, or did it have animus? And in the case of the Fourth Circuit, it found that likely there was no secular purpose. There was animus. We need to only look at A, B, and C to make that determination. It would be still remarkable for the U.S. Supreme Court to make a decision around the Establishment Clause and foreign policy, right? We don't have a lot of decision-making in that arena. It may be that the court makes its decision on statutory grounds. I think that might be an easier way, maybe, right? I shouldn't really be the one to make a hypothesis, but you have the Immigration and Nationality Act. at the core of the Immigration and Nationality Act is family, right? So if you look at immigrant visas, the vast majority of immigrant visas are allocated to family. Point one, right? Point two, we have a section in the Immigration and Nationality Act called 212F. That's the provision that the president has relied upon to say that a president may suspend the entry of any class of aliens if their entry is detrimental to the interests of the United States, or something along those lines. And so the government has said, under 212F, I have authority to block anyone I want from coming into the United States, and courts can't step in, because that is a foreign policy, and if you need a rationale, it's national security. Similarly, the scope of 212F, this idea of suspension, is not unfettered. So the government has tried to go back to earlier points in history where 212F was used, but those scenarios were far more limited, and in most cases had a rationale. And here I think we have a situation where the president has really exceeded the statutory scope of 212F.
Now, I can't let you leave here without asking you, what do you think is going to happen? When people, the week before the Super Bowl, people made predictions as to who's going to win, who's going to lose. I want to know, based on all the time and effort that you have put in, how do you see the court ruling? Do you see the 5-4 ruling one way or the other, 7-2 one way or the other? What's your prediction as to when they hear oral arguments and they come up with a decision? What would you guess, based on which way the winds are blowing currently, that you would predict this will be?
So if I have to analogize this
Yes.
to Super Bowl,
Sorry
I'm in central Pennsylvania, okay? So we're Steel country. It's Penn State and the Steelers. Once the Steelers lost,
You lost interest.
no more predictions. Yeah. So I could just use that as my
Even though
analogy.
Pennsylvania team ended up winning.
Yes. Philadelphia.
Yeah.
Not central Pennsylvania, but yes, Pennsylvania was happy. So, I don't know. Arsalan, I don't have a magic 8 ball.
I know.
Nor do I have a crystal ball. I wish I did. I think there's a...
But did you?
Let me answer this
Let
way.
me pause you there. Did you think that the Supreme Court was going to let, even before the appellate court rulings came out, they were going to, say we're going to?
No,
right.
I did
No,
not see that coming.
I don't think any lawyer saw that coming.
Yeah, I did not see those twin orders on
Yeah.
December 5th. They were stunning.
And there was I only read one. I saw 8-1 somewhere, and I saw Sotomayor dissented. If I'm not mistaken. What was RBG thinking? What were that's what I was trying to get at.
Yeah, well, first, who knows what the court is thinking? I do want to say that the December 4th ruling, I don't want to call it a prognosis for what's to come, because the ruling did not make any decision on the merits. Or the legality of the proclamation, right? The ruling simply said, while this case plays out, we're going to reinstate the proclamation. But it is cause for concern, right? It certainly concerns me, and we have our wild cards, right? Like Kennedy and Roberts, and how they might rule. Let me say this, I think if we win, I am inclined to believe it will be on statutory grounds. And if we lose, I won't be surprised.
I won't either. And what impact, if we did lose, God forbid, but what impact do you think that would have on immigration moving forward in this country?
Much will depend on what the basis is, right? So what doctrine is invoked will really, I think, help inform and dictate what the future of immigration litigation looks like. And the impact on the ground will be both sobering, but what we've also seen is a lot of resilience, right? So I don't think the resilience of the communities impacted by these bans will change, but I think it will be a real blow, and also cause us to really question our American identity and make the Bridge Initiative have to hire twice as many staff, right? To reclaim and reframe some of the debate.